Hello, friends. So, without any further delay, let's start our Indian Polity Last Lap series lecture. And I will cover thoroughly everything, what is very, very important according to PYQ themes, according to current affairs, and also according to the static coverage. So, let's start. These all themes we will be covering. It's as aligned as our Lakshmikant book, so you won't have any kind of difficulty in terms of structuring as well. So, the first unit is historical background. The Government of India Acts. These acts inspired our present constitution. Many of the provisions that have come in our present constitution have taken an inspiration from these acts. So the first is Regulating Act 1773, as the name suggests. Now, the East India Company was to be regulated because before that they were running like unruly horse. So it was a first step taken by the British government to control and regulate the affairs of East India Company. And then they laid down a central administration in India. A post to head that was established, that was Governor General of Bengal. And who was the first one? Lord Warren Hastings. Not only that, it provided for the establishment of Supreme Court at Calcutta in 1774. It also had original as well as appellate jurisdiction, comprising one Chief Justice and 3 other judges. The presidencies of Bombay and Madras were made subordinate to the presidency of Bengal. Then only there will be supremacy of the central post. If they are not subordinate, then how it will be supreme? Then Act was amended in 1781, also known as Act of Settlement or Declaratory Act of 1781. So it was passed by the British Parliament to rectify some of the defects which remained in this Regulating Act of 1773. It exempted the Governor General and the Council from the jurisdiction of the Supreme Court for acts done by them in their official capacity. Otherwise, they will be going behind the litigations only. It also exempted the servants of the company from the jurisdiction of the Supreme Court for their official actions. So, providing a bit of upper hand. It excluded revenue matters and matters arising in the collection of revenue from the jurisdiction of the Supreme Court as well. This was their main way to earn more and more. And thus they wanted to be aloof from the judicial scrutiny. It provided that the Supreme Court was to have jurisdiction over all the inhabitants of Calcutta and required the court to administer the personal law of defendants. Hindus were to be tried according to Hindu law. This can become a prelim statement. Muslims according to Mohammedan law. Appeals from provincial court could be taken to the Governor General in Council, not to the Supreme Court. From provincial court, it will go to Governor General in Council, not to the Supreme Court. This was done through the Amending Act of 1781. Now came just after 3 years of this, Pitt's India Act of 1784. Now all the Indian affairs came under the direct control of the British government. Britain for the first time, this is something which is very important to know. Now they are trying to have more control over the East India Company. Why they are trying to do so? So when Robert Clive went from India to the Britain, and he took with himself a lot of bounty, a lot of money. Trial also happened, and he was punished as well. So now the officials of Britain also came to know that they are looting a lot. Now it's a time to have a pie to regulate them. Distinguished between the commercial and political functions of the company. Commercial and political. It's kind of a separation of power. Okay. Allowed the court of directors to manage commercial affairs. The court of directors will manage commercial affairs. Created a new body called Board of Control, 6 members to manage the political affairs. It will supervise and direct all operation of the civil, military, and revenue of British possessions in India. Thus, it established a system of dual government in India. If the statement comes, who established the dual government in India? It has to be Pitt's India Act of 1784. Then Act of 1786. It was a very small kind of a modification. So Lord Cornwallis was appointed as the Governor General of Bengal. He placed 2 conditions. One, he should be given power to override the decision of his council in special cases. And second, he would also be the commander-in-chief. The Act of 1786 was enacted to incorporate both the provisions which was demanded by Lord Cornwallis. Now comes the Charter Act of 1793. it is giving more and more power to specifically the Governor General. Now, what will happen is it will extend the overriding power given to Lord Cornwallis over his council to all future Governor Generals and Governor of Presidency. So it was extended not just for Cornwallis, but for the person who will assume the post in the future as well. Then extended the trade monopoly of the company in India for another 2 decades. Another 2 decades. So until 1813, though, now it is established, done. Provided that the commander-in-chief was not to be a member of the Governor-General's Council unless specifically appointed as such. So commander-in-chief was not to be a member of Governor-General Council, again trying to establish a separation. Then members of the Board of Control and their staff were henceforth to be paid out of Indian revenues. So we are paying for our own misery. Then comes Charter Act of 1813, more important for your prelims examination. It ended the monopoly of the East India Company in India, except the company's monopoly in trade with China and trade in tea with India. So company's monopoly in trade with China remained and trade in tea with India remained. Thus, trade with India for all other commodities was thrown open to all British subjects. First time, the constitutional position of British territories in India was explicitly defined, asserted the sovereignty of the British Crown. So they're saying that British Crown will assert. They are asserting their sovereignty. They're trying to curtail the power and freedom that was given to East India Company over the company's territories in India. So this can become a probable prelims statement. Allowed Christian missionaries. This became the sparking point for the 1857 revolt later on. You are meddling with the culture of people of India, and that is never tolerated. To come to India for the purpose of enlightening the people. Then provided for this is something which has been asked in several of the PYQs. So it provided for the spread of Western education among the inhabitants of the British territories in India, allocated 1 lakh rupees for education. So they were now trying to also impart Western education and allocated money for it as well. Then authorized local governments in India to impose taxes on person and to punish persons for non-payment. So local governments in India can impose taxes on person, and if you are not paying it, they can punish as well. Another very important act, Charter Act of 1833. So it was a final nail in the coffin, final step towards centralization in British India, because now the Governor General of Bengal became the Governor General of India. And who was the first one? It was Lord William Bentinck. Lord William Bentinck was first Governor General of India. So the Governor General was vested with all civil and military powers. It deprived the Governor of Bombay and Madras of their legislative powers. The Governor General of India was given exclusive legislative powers for the entire British India. Something like a central government was established finally. The laws made under previous acts were known as regulations. The laws made under this acts were known as acts. So previously, the previous acts were known as regulation. Now, after this, it will be known as acts. Ended the activities of East India Company as a commercial body. It became purely an administrative body. So now it was no longer a commercial body, but it became a purely administrative body. And it introduced a law member. Macaulay became the law member in the Governor General's Council. There is a statement given by Macaulay that 1 shelf of the books of Western philosophy has more knowledge than the entire Oriental books and knowledge. This was what he believed, but it wasn't true. This is something which is trying to prove the white man burden theory and trying to establish the superiority of the whites over the Indian people and other people as well, which was debunked later on. It was debunked when the Archaeological Survey of India will unearth a lot of wisdom, a lot of knowledge, and it will be known to them that there existed a civilization, industrial civilization, long before the people of Britain even wore clothes properly. We had a civilization as magnificent as one can imagine. Then comes the Charter Act of 1853. So it separated the legislative and executive functions of the Governor General's Council for the first time. Separation of power in real manner was established in Charter Act of 1853. And if this will come in the prelims, and they will ask you that separation of power was established through which act, and there will be options, then you have to take Charter Act of 1853. Why so? Because the legislative and executive function of Governor General's Council for the first time was separated. Not only that, it provided for the 6 new members called legislative councillors to the council. This constituted the Indian Legislative Council. So legislative councillors also now began to come, and it was called as Indian Legislative Council. First time local representation was introduced in the Indian Legislative Council. So first time when the local representative was introduced in Indian Legislative Council, it was in 1853 Act. Another first time open competition was introduced for civil services. The covenanted civil services or the coveted civil services was thrown open to Indian also. Okay. So this is something which you need to know. Governor generals could veto a bill as well. Restrictions on immigration of Europeans and their right to acquire property was filled. Okay. There could be a confusion with respect to the 1833 Act. 1833 Act introduced the open competition in civil services, or 1853 Act which opened, throwed open Indians to participate in the civil services. The Charter Act of 1833 attempted to introduce an open competition system for civil services requirement, which aimed to end the patronage system. However, this provision was not effectively implemented due to opposition from the Court of Directors, and open competition was formally established later by the Charter Act of 1853. So it attempted, though, the Charter Act of 1833, but it was formally introduced in the 1853. This is the complete knowledge that you should have. Governor General could veto a bill is an important provision. Restrictions on immigration of Europeans and their right to acquire property were lifted. Now they can come, they can acquire property, they can do whatever they want. Indian laws were codified and consolidated. No Indian could be denied employment in the company on the basis of religion, color, creed, or place of birth. It's an important provisions, and probably you don't cram it, but it's important. It can come. It abolished the slavery as well. Now, after the Great War of First Independence, 1857 revolt, Government of India Act of 1858 was passed. It is also known as Act for the Good Government of India. Rule of company was replaced by rule of crown, and it changed the designation of the Governor General of India to the Viceroy of India. What is the difference between a Governor General and a Viceroy? Viceroy is a direct agent of the crown. Something like governors, no? They are also an agent of the president. So you can assume something similar. That is the difference. Then the act abolished the dual government established by the Pitt's India Act of 1784. It also ended the doctrine of lapse, which led to the spark of 1857 revolt. The Secretary of State for India was a member of the British cabinet, okay, and was ultimately responsible to the British Parliament. So established a 15-member Council of India to assist the Secretary of State. This is a new position, an important position which was established. The Secretary of State could be sued in India and in England, both. Okay. Then comes the Indian Council Act of 1861. It initiated the process of decentralization, because overtly the centralization process was happening, and India is a mammoth country. India is a country of humongous diversity. We have diverse kind of interests and diverse kind of problems as well. So it was something which was leading to difficulties. So now they try to initiate the process of decentralization by restoring legislative powers to Bombay and Madras. These powers had been taken away by the Charter Act of 1833, when the Governor General became the Governor General of India. It also introduced representative institutions in India by associating Indians with the law-making process. As it is, this statement will come. Which act associated Indians with the law-making process? It has to be Indian Council Act of 1861. Then the Viceroy nominated some Indians as non-official members of his expanded council. 3 Indians were nominated. Who were they? The Raja of Banaras, the Maharaja of Patiala, and Sir Dinkar Rao. Non-official members of his expanded council, 3 Indians were nominated. Raja of Banaras, the Maharaja of Patiala, and Sir Dinkar Rao. These names are important. Empower the Viceroy to issue ordinances during an emergency. See, all the things you are seeing in the Constitution, many of the things have come from these acts. It empowered the Viceroy to frame the rules of business. The same power is given to the President of India under Article 77 of the Constitution. So it created new legislative councils for Bengal, Northwest Frontier provinces, and Punjab. So they were trying to create more and more decentralization. So they created new legislative councils as well. Then it gave statutory recognition to the portfolio system introduced by Lord Kelly. Okay, the different portfolios. Now you see, if you have different ministries, so they are handling different portfolios: health, education, defense. Then comes the Indian Council Act of 1892, from where the propaganda in legislative started. So Though the majority of the official members were retained, the non-official members of the Indian Legislative Councils were henceforth to be nominated by the Bengal Chamber of Commerce and the Provincial Legislative Councils. So non-official members of the provincial councils were to be nominated by certain local bodies such as universities, district boards, and municipality. Now, the next statement is very important for your examination. This marked the beginning of the representative system in India, that is, indirect elections came from Indian Council Act of 1892. The council was given the power to discuss the budget and to address questions to the executive. So the council was given the power to discuss the budget. Now here the propaganda will start. Leaders like Firoz Shah Mehta will try to question the policies of the Britain and to address the questions to the executive. Then comes the important one, Indian Council Act of 1989, something which wanted to create a divide and rule in the nation. Something which Curzon envisaged through the partition of Bengal. So parliamentary reforms. It introduced for the first time an element of elections to the Legislative Council. At the provincial legislative councils, non-official members were to be in majority. Okay, so first time an element of elections to the legislative councils were introduced here. Second is, it introduced the concept of separate electorates for Muslims. So this is something which is very important for examination. A representation in excess of their population was accorded to Muslims, and the income qualification for Muslim voters were kept low. They were giving carrot to Muslims and stick to Hindus. For the first time, associations of Indians with the Executive Council of the Viceroy and Governors was provided, and who became Satyendra Prasad Sinha, SP Sinha, became the first Indian to join the Viceroy's Executive Council as the law member. Then comes your Government of India Act of 1909, known as Montagu-Chelmsford Reforms. It introduced the concept of responsible government. The office of the High Commissioner of India was created in London. The Indian legislature became bicameral for the first time. At the center, two houses were established. At the center, communal representation was extended to Sikhs, Indian Christians, Anglo-Indians, and Europeans. Muslims had already been given in 1909. The Secretary of State for India was henceforth to be paid from British revenues, not Indian revenues. It introduced diarchy in the provinces. Diarchy means there were two subjects. One was transferred, second was reserved. Reserved included the more important ones because it was administered by the governor with his executive council without any responsibility to the legislature. So everything which needed to control and to exploit the people, it is the most important tool to exploit people, can be police, can be finance, extract more and more revenues. Okay. These important things became part of the reserved subject. Transferred were administered by the governor with ministers responsible to the legislature, and it included perhaps things which were lesser important for them. They were not paying heed for education or public health or local self-government. Local self-government, though, is not paid heed even now. And this was the PYQ which was asked, and people became confused. So reserved means more control. Local self-government is still not getting the importance that it should get. It also devolved legislative authority from the center to the provinces by separating central and provincial subjects. Now, the another thing is, when was a reservation for women introduced in India? Okay, was it Government of India Act 1919 or was it 1935? So this is a favorite question of again UPSC, and you get confused. So what is the complete information? See, while the 1919 Act was a major step, it only allowed provinces the option to grant women the right to vote, which was still restricted by property and education qualification. So if you see, it gave in 1919 Act gave limited franchise. It gave some women the right to vote for the first time, but this was not universal. Then there was no reserved seat. The Act did not provide for the reservation of seats for women in the legislatures, and provinces were provided option. So it left the decision of whether to admit women to the franchise to the newly elected legislative council of each provinces. Then Government of India Act 1935 came. So this act formally introduced reserved seats for women in both provincial and central legislature. And these seats were allocated on a communal basis, that is separate electorates for women within specific communities. And it significantly expanded the number of women eligible to vote, though universal suffrage was still not achieved until the constitution came into the force. And in modern India, we are discussing about the Nari Shakti Vandan Adhiniyam, 106th Amendment Act in 2023, and the recent act which was introduced. Okay. So this is what you need to know. The complete informations are always needed, which are not given usually in the books. Okay. Then comes the most important one, the Government of India Act 1935. So it introduced, first of all, the federal structure. You see the federal structure in the present independent India. So it proposed an all India federation consisting of British provinces and princely states, though this provision never fully materialized. Okay. So this is also which you need to know. Second is it provided provinces the autonomy now. It replaced the diarchy with provincial autonomy. 1919 introduced diarchy to the provinces, allowing elected Indian ministers to lead provincial department for the first time. Then they only introduced the three list of powers. It divided legislative powers into the federal list, provincial list, and concurrent list, a system which is still there. Then it established, it provided for the creation of the federal court, which was a precursor to the Supreme Court, and the Reserve Bank of India as well. While it gave women reserved seats, it did so through separate electorates, meaning only women from specific communities could vote for women candidates within those communities. Okay. It also introduced bicameralism in 6 out of 11 provinces. Then it extended the principle of communal representation by providing separate electorates for depressed classes, women, and labor workers. Previously, 1999, only Muslims. So workers also they were trying to. We have a reaction that is by the Mahatma Gandhi, and then a Pune Pact is established, and this was replaced with the joint electorate with reservation. Abolished the Council of India established by the Government of India Act of 1858. The Secretary of State for India was provided with a team of advisor. And not only this, it established the Federal Public Service Commission, Provincial Public Service Commission, and Joint Public Service Commission as well. Okay, so these are the things which you need to know. Now let's come to Indian Independence Act of 1947. On 20th February 1947, Prime Minister Clement Attlee declared the British rule would end by 30th June 1948. The Mountbatten Plan, which was accepted on 3rd June 1947, declared India as an independent and sovereign state from 15th August 1947. It provided for the creation of two independent dominions, India and Pakistan. With the right to secede from the British Commonwealth, the Governor-General of each was to be appointed by the King on the advice of the Dominion Cabinet. It empowered the Constituent Assemblies of both dominions to frame and adopt any constitution and to repeal any act of the British Parliament, including the Independence Act itself. It abolished the office of Secretary of State for India and transferred his function to the Secretary of State for Commonwealth Affairs. It assigned dual function, constituent and legislative, to the Constituent Assembly formed in 1946, and it became kind of a first parliament. This made the Constituent Assembly a fully sovereign body and also the Parliament of Free India Dominion Legislature. It granted freedom to India, to Indian princely states to either join the Dominion of India, join the Dominion of Pakistan, or remain independent. From here, the problem of Kashmir arises. Here, the Sardar Patel played an immense role. This is the provision that they gave. And then Nehruji gave a speech after India became independent. It's something which is very historical speech and something which you all should at least listen if you haven't listened. It starts like, long years ago, we made a tryst with destiny, and now the time comes when we shall redeem our pledge. At the stroke of the midnight hour, when the world sleeps, India will awake to life and freedom, by the Pandit Jawaharlal Nehru. Then the making of the Constitution, a mammoth task, but we did it brilliantly. Thanks to the founding father of the Constitution, they deliberated. It's not all the provision that you see now. And we also think that why these were introduced after a due deliberation. And even though there are a lot of criticism that it was a lawyer's paradise and it's a Congress constitution, whatnot, but it had representation from various sections of the society. It had women, it had tribals, it had Muslims, it has Hindus, it has Christians, and from the all section of the society. So if you see the timeline of the Constituent Assembly, there was a gentleman named M.N. Roy, a stalwart of communists. So the idea of Constituent Assembly for India was put forward for the first time by M.N. Roy, a pioneer of the communist movement in India, someone who went to Soviet Union as well to take participation. In 1935, the Indian National Congress for the first time officially demanded Constituent Assembly to frame the Constitution of India. Then in 1938, Jawaharlal Nehru declared that Constitution must be framed without outside interference by a Constituent Assembly elected on the basis of adult franchise. 1940, the August offer, the British government accepted the demand for a Constituent Assembly. Then in 1942, Sir Stafford Cripps came to India with a draft proposal on framing an independent constitution after World War II. The proposal was rejected by the Muslim League. And in November 1946, the Constituent Assembly was constituted under the scheme formulated by the Cabinet Mission Plan. Members were indirectly elected by the members of the provincial assemblies, who themselves were elected on a limited franchise. Then comes the 9 December 1946, first meeting of the Constituent Assembly. The Muslim League boycotted the meeting, and Sachindranath Sinha was made the temporary president, following the French practice of electing the oldest member as temporary chairman. Very, very important. Now also the pro tem speaker usually is the senior most one, right? Then 11 December 1946, Dr. Rajendra Prasad was elected as the president of the assembly. H.C. Mukherjee and V.T. Krishnamachari were elected as vice president. Then on 13 December 1946, Jawaharlal Nehru moved the historic objective resolution, which is set out the philosophy of the constitutional structure in the assembly, something which is inspired by the preamble of the Indian Constitution. Then on 22nd January 1947, the objective resolution was adopted by the Constituent Assembly. It gave direction to our Constituent Assembly. Then 3rd June 1947, Mountbatten Plan was accepted. After Independence Act 1947, the Constituent Assembly became a fully sovereign body. It also became a legislative body. When it met as the constituent body, it was chaired by Dr. Rajendra Prasad. When it met as the legislative body, it was chaired by G.V. Mavlankar. Both functions continued until 26 November 1949. 26 November 1949, the Constitution was adopted. It contained a preamble, 22 parts, 395 articles, and 8 schedules. The preamble was enacted after the entire Constitution was already enacted. Okay, so in last it was enacted. On the 26th January 1950, the Constitution came into force. India became a republic. Now, other functions performed by the Constituent Assembly was it ratified the India's membership of Commonwealth in May 1949. Second, it adopted the national flag on 22nd July 1947. Third, it adopted the national anthem on 24 January 1950. Then it adopted the national song on 24 January 1950 and elected Dr. Rajendra Prasad as the first president of India on 24 January 1950. So here is the sequence. First, membership of Commonwealth, then comes the flag, then comes the anthem and song, and then the election of Dr. Rajendra Prasad ji as the first president of India. This sequence is important for your examination. Now, provisions that came already into force on 26 November 1949 is important. Some provisions came into force on 26 November 1949 itself, like Article 5, 6, 7, 8, 9, 60, 324, 366, and 367, 379, 80, 388, 391, 392, and 393. When we will read about these provisions, we will understand it. These pertain to citizenship, elections, provisional parliament, temporary and transitional provisions, and short titles. Okay, this you need to cram. Now, there were some major committees of the Constituent Assembly. The first one and the most important one was drafting committee, Prarup Samiti in Hindi it is called, headed by none other than the Baba Sahab, Dr. Bhim Rao Ambedkar ji. And then comes the steering committee. It was headed by Dr. Rajendra Prasad. Union Powers Committee was headed by Jawaharlal Nehru. Union Constitution Committee was also headed by Dr. Jawaharlal Nehru, Pandit Jawaharlal Nehru, no doctor. Then Provincial Constitution Committee by Sardar Vallabhbhai Patel. The drafting committee was set up on 29th August 1947. It consisted of 7 members. Baba Sahib was chairman, then N. Gopalaswamy Iyengar was a member, Alladi Krishna Swamy Iyer was a member, Dr. K. Munshi was a member, Sayyid Muhammad Sadaullah was a member, and Madhav Rao replaced B.L. Mittar, who resigned due to his ill health. Then T.T. Krishnamachari replaced the D.P. Khaitan, who died in 1948. Okay. Then comes the third chapter, Salient Features and Sources of the Constitution. So our Constitution is lengthiest written Constitution. The Constitution originally contained a preamble, 395 articles, divided into 22 parts and 8 schedules. It is the lengthiest written Constitution in the entire world. And it draws inspiration from various sources, and the critics say that it is a patchwork. Even if it is a patchwork, it is a beautiful patchwork. Okay, this is the reply by some of the political scientists. It blended the rigidity as well as flexibility. So a completely rigid constitution requires a special procedure for amendment. Example, the American Constitution. A flexible constitution can be amended in the same manner as ordinary laws like the British Constitution. So the Constitution of India is neither rigid nor flexible, but a synthesis of both. Okay. Then comes the federal system with unitary bias. So Article 1 defines India as a union of states, not a federation of states. India has usual federal structures, two governments, division of power, written constitution, supremacy of constitution, rigid constitution, independent judiciary, and bicameralism, but also has unitary features. We have rigid provisions in the constitution, not completely rigid constitution. Like it has strong center, single constitution, it has single citizenship, it has flexibility in the constitution, it has integrated judiciary, appointment of state governance by the center, all India services and emergency provisions provided unitary bias as well. It is sui generis. Casey Ware says that it is one of its kind. Then we have parliamentary form of government, also known as Westminster model, responsible government or cabinet government. The executive council, that is council of ministers, remain responsible to the legislature. That is very important feature of parliamentary form. The Indian parliament is not a sovereign body like the British parliament. India has an elected head, republic, while Britain has a hereditary head, monarchy. So it is not completely sovereign. Secondly, India has an elected head, Britain has a hereditary head. That is the difference with the Westminster model. Then synthesis of parliamentary sovereignty and judicial supremacy. So the doctrine of sovereignty of parliament is associated with the British parliament. The principle of judicial supremacy is associated with the American Supreme Court. The Indian Constitution is again synthesizing the both. Then we have integrated and independent judiciary. So a single system of courts enforces both central laws and state laws. In the United States, the federal judiciary enforces federal laws and state judiciaries enforces state laws. That's the difference. Then we have single citizenship. So though the Constitution is federal and envisages a dual polity, center and state, it provides for only a single citizenship, Indian citizenship. There is no separate state citizenship in the India. Okay. Then the sources of the Constitution. So the Government of India Act inspired a lot of things like the federal scheme, the Office of Governor, the Judiciary, the Public Service Commission, the emergency provisions, and administrative details. In emergency provisions, the suspension of fundamental rights, etc., is not inspired from Government of India Act 1935. It comes from the Weimar. Then British Constitution, the parliamentary government, rule of law, legislative procedure, single citizenship, cabinet system, prerogative rights, parliamentary privileges, and bicameralism. US Constitution, fundamental rights, independence of judiciary, judicial review, impeachment of the president, removal of Supreme Court and High Court judges, and the post of vice president. And Irish Constitution, DPSP comes from here, has taken inspiration from here, not all the DPSP are same. Nomination of members to Rajya Sabha and the method of election of the president, all three have come from the Irish Constitution. Then Canadian Constitution, federation with a strong center, vesting of residuary power in the center, appointment of state governors by the center, and advisory jurisdiction of the Supreme Court. Australian Constitution, the concurrent list, the freedom of trade, commerce, and intercourse, and joint sitting of the two houses of Parliament. Okay. So this has, as I was telling about the Weimar Constitution, that is suspension of fundamental rights during emergency. So you must have, when we will be reading about the emergency provisions, then we will be dealing in detail with respect to when the fundamental rights are suspended during emergency. The Article 301 declares that trade, commerce, and intercourse throughout the territory of India shall be free, which is mentioned in the Australian Constitution. Okay. Soviet Constitution also inspired many things like fundamental duties and the ideal of justice, socio-economic and political in the Preamble. French Constitution, the Republic, and the ideals of liberty, equality, and fraternity in the Preamble came from the French Revolution. South African Constitution, procedure for amendment of the Constitution and election of members of Rajya Sabha. Japanese Constitution, procedure established by law in the context of Article 21, protection of life and personal liberty, has taken inspiration from the Japanese Constitution. Now let's see Preamble of the Constitution. So as discussed earlier, it drew its inspiration from the objective resolution, which was moved by Pandit Jawaharlal Nehru. Now it has been amended also by the 42nd Constitutional Amendment Act in 1976, which added 3 new words: socialist, secular, and integrity. And there was a PYQ question in that UPSC had asked the exact status. Exact status was asked. So in that, secular and socialist, etc., whatever, not there, since the word exact was added. Now, the meaning of words, this has been also asked by UPSC in the various years. Many times they have asked. One is the sovereign. Sovereign means that India is not a dependent of to any country or a dominion to any country. We are free to take decision internally and externally. Externally means we are free to have any kind of a relationship with any other country. That's our right. And internally, how we have to rule, that also will be decided by an independent state elected by people. Socialist. So even though the Congress party adopted a resolution to establish a socialist pattern of society, since our leaders like Subhash Bose, Pandit Jawaharlal Nehru, etc., were so much into the socialism. So at its Saudi session, Indian brand of socialism is Fabian socialism or democratic socialism, not communistic socialism. It can be also termed as state socialism. So democratic socialism holds faith in a mixed economy where both public and private sector will coexist, not like everything is owned by the public sector. Indian socialism is a blend of Marxism and Gandhism, leaning heavily toward Gandhian socialism. The idea of stateless society was the utopia of Gandhiji. Okay. This was also asked by UPSC in one of the year. Then comes secular. So the word in the preamble was added in the 42nd Constitutional Amendment Act, but India, in the provisions, India always followed a positive secularism. That is not having arm's length principle like French Constitution. Here, the state is positively interacting with the religion. They are trying to positively contribute as well. And all religions in the country, irrespective of their strength, have the same status and support from the state. Then democratic. So based on the people are sovereign, based on the popular sovereignty. So position of supreme power is with the people. We are not direct democracy. Direct democracy is in countries like Switzerland, where there is a referendum, initiative, recall, plebiscite. It's such a mammoth country, these things are not possible. So in India, we have indirect democracy, where elected representatives exercise supreme power. And India follows this form. And the principles of liberty, equality, and fraternity forms a union of trinity. To divorce one from the other is to defeat the very purpose of democracy. Why so? Okay. If you have liberty but not equality, so can you exercise your own desires? Can you exercise your own skill set? No, because there is no equality. And if there is an equality without fraternity will have constant quarrels in the society, us versus them. So we cannot divorce them. This is a whole one. If one has to exist, the other has to also exist. A stratified society cannot have a true liberty. Then we have republic. Republic means the head of state is elected one and elected for a fixed tenure. It also means that the political sovereignty is with the people, not with any king. And there is an absence of any privileged class. All the public offices are open for all the people. This is the complete meaning of republic. Then comes justice. So the ideal of justice, socio-economic and political, has been taken from the Russian Revolution of 1917. Then comes liberty. So liberty means the absence of restraints on the activities of individual. And not only that, at the same time, the state will provide opportunities for the development of individual personalities as well. The preamble secures to all citizens of India, it is given there, but liberty of thought, expression, belief, faith, and worship. If we will go to our fundamental rights also, there also these things are mentioned. Then equality, the absence of any special privileges, anything which is just based on class, ascription-based society, like caste-based privileges has to end. And the provision of adequate opportunities for all individuals without any discrimination of sex, any race, any class, any caste, any language. There should be equality. Then fraternity, so sense of brotherhood, to assure two things: the dignity of the individual and the unity and integrity of the nation. Both is needed. If there is no fraternity, then at the individual level, there will not be any dignity. And at the collective level, there will not be any unity and integrity of the nation. And the integrity word was added to the preamble of the Constitution in 42nd Amendment. Now the status of preamble. Is it part of the Constitution or it is not part of the Constitution? This had been asked a lot of times, and there have been so many judicial pronouncements with respect to it. So the first case which talked about it was Berubari Union case. So Supreme Court specifically opinioned that the preamble is not a part of the Constitution. It started from here. Then comes the Kesavananda Bharati case, 1973. Supreme Court held that the preamble is part of the Constitution because the same procedure through which other parts were enacted. Through the same process, the preamble was also enacted. That was said by the Honorable Supreme Court. Then comes the LIC case. Supreme Court again held that preamble is an integral part of the Constitution. Now, some of the important points about the preamble is, like any other part of the Constitution, the preamble was enacted by the Constituent Assembly. But after the rest of the Constitution was already enacted. Then the preamble is neither a source of power, very important. It is not a source of power to the legislature, nor a prohibition upon the power of the legislature. Very, very important point. So neither legislature can take power from preamble, nor it prohibits the legislature. It is non-justiciable, means its provisions are not enforceable in court of law. Okay. However, the preamble procedures can be read with other procedures, other provisions in the Constitution, and then any pronouncement can come. Alone, if you talk about, then it is not justiciable. But with other provisions, it can become. This is also a trap which was asked by UPSC in past. The preamble can be amended subject to the condition that no amendment is done to the basic feature of the Constitution. We will discuss about it as given in the Kesavananda Bharati case. The fundamental features of the Constitution as contained in the preamble cannot be altered by an amendment under Article 360. Okay, 8. Okay. The preamble has been amended only once in 1976. Then the next part, your fundamental rights. So it is enshrined in the part 3 of the Constitution and called as the Magna Carta of India. So they derive inspiration from the Constitution of the United States of America, where the Bill of Rights was enacted. And it is meant for promoting the ideal of political democracy. This can be asked. So why it has been enacted? For political democracy. They protect the liberties and freedom of the people against invasion by the state. Otherwise, the state will invade in your right, your dignity. Now, key features of the fundamental rights. This attracts more questions. So some fundamental rights are available only to citizens, while others are available to all persons, whether citizens, foreigners, or legal persons like corporation or company. So which fundamental rights are only available to citizens? That is important. Can you answer it? You can pause and answer it. I will discuss anyhow, but pause it and answer it. This is an important part and everybody should know it. So if you see, fundamental rights which are exclusive to citizens are Article 15, protection against discrimination based on religion, race, caste, sex, or place of birth. Then Article 16, equal opportunity in public employment. Then Article 19, protection from 6 key freedoms such as speech and assembly, etc., etc. Then Article 29 and 30, protections regarding the cultural and education rights of specifically the minorities. Okay, so these are exclusive for the citizen. They are not absolute but qualified. It's not absolute. The state can impose reasonable restrictions on them. All of them are available against arbitrary action of the state. Some of them are also available against actions of private individuals. So which fundamental rights are also available against actions of private individual? This can be your question or perhaps a statement. What all this? Again, pause and answer. So while most fundamental rights provide protection against the state, there are specific rights that can be enforced against private individuals as well. Like your Article 15 Clause 2 prohibits any person from discriminating against another regarding access to shops, public restaurants, hotels, and places of public entertainment. This can be there. Article 17, that is abolishing untouchability and forbids its practice in any form. This is an absolute right enforceable against both the state and private individual. Then Article 23 prohibits human trafficking and forced labor, that is begar. It protects individual from exploitation by private employee or contractors as well. Then your Article 24 prohibits the employment of children under 14 in factories, mines, or hazardous occupations, regardless of whether the employer is a private entity or the state. So these are the ones. Now, another thing is that some of them are negative in character. What does that mean? What does that mean? That means that they are placing limitations on the authority of the state. Okay, like Article 14 says that state shall not deny to any person equality before the law. It's negatively it is trying to put limitation on the authority of the state. Yeah, Article 15 Clause 1, the state shall not discriminate against any citizen. Or Article 21, no person shall be deprived of his life or personal liberty except according to procedure established by law. Okay. Then they are justiciable, that is enforceable by courts. They are not sacrosanct or permanent. If it is a statement that they are sacrosanct or permanent, they can be amended, right? They can be changed, right? Parliament can curtail or repeal them, but only by a constitutional amendment act and not by an ordinary act. They can be suspended during a national emergency except rights guaranteed by Article 20 and 21. The sixth rights under Article 19 can be suspended only when an emergency is declared on the grounds of war or external aggression. यहाँ से एक statement बन गया. Their application can be restricted while martial law is in force in any area. Then let's see Article 12, that is definition of state. So here the definition of state becomes important because they can ask you any question which of the below things comes under the definition of state. So, according to Article 12, the term includes the following: Government and Parliament of India, the executive and legislature organs of the Union government, first of all. Second, government and legislature of states. Then, local authorities like your municipalities, panchayats, district boards, and improvement trust. Other authorities, bodies within India are under the control of the government of India will also come. So what are the other authorities? That is statutory corporation like LIC, ONGC, and the International Airport Authority. Registered societies like CSIR was confirmed as a state in the Pradeep Kumar Biswas case because of deep government control. Then bodies with public function, any entity performing functions of public importance or enjoying a government protected monopoly. And judiciary has taken the position of the judiciary. So the judiciary is not explicitly mentioned in Article 12. Its status is nuanced. So when court performs administrative tasks like staff appointment or conducting exams, they are considered as state and can be challenged for violating rights. In judicial capacity, when delivering judgment or performing judicial functions, they are not considered state under Article 12. Consequently, a superior court's judicial decisions cannot be challenged as a violation of fundamental right. Okay, so this is what you need to know. Then Article 13, laws inconsistent with fundamental rights. So Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. This provides for the doctrine of judicial review. Okay. The term law in Article 13 includes permanent laws enacted by the center and state, temporary ordinances by the president, statutory instruments of delegated legislations, executive legislations like orders, bylaws, rules, regulations, and notifications, customs and usage having the force of law. Okay. Then Constitutional Amendment Act are not included within the meaning of law under Article 13. The Supreme Court held in Kesavananda Bharati case 1973 that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution, hence can be declared void. This was the tussle which was going on between the executive and the judiciary, specifically in the 1970s. Then we have right to equality. It consists of Article 14 to 18. Okay. So equality before law and equal protection of law. That means the state shall not deny to any person equality before the law or the equal protection of the law. Equality before the law, what does it mean? So it is a negative concept as it is worded. The Supreme Court held that rule of law is embodied in Article 14 and is a basic structure, it's part of the basic structure doctrine. It means absence of any special privilege in favor of any person, first thing. Second, equal subjection of all persons in the ordinary law of the land administered by the ordinary law courts. And the last one is no person is above the law. This means the equality before law. Now, equal protection of law. So it has been taken from the American Constitution. It is a positive concept. There are three implications of it. One is equality of treatment under equal circumstances. So equal circumstances are there, then equality of treatment will be there. The similar application of the same laws to all persons, the like should be treated alike without any discrimination. Now, what does it mean? Like should be treated alike without any discrimination. So, like means a similar circumstances or situation. Okay. People who are similarly situated must be given the same rights and be subject to the same liabilities. You cannot treat an underprivileged person and a highly privileged person exactly the same and call it fair. Okay, in terms of fine, etc. These things can be taken into the grounds. While equality before law is a negative concept, the equal protection of law is a positive concept. Okay. It places a positive duty on the state to take active steps to ensure that everyone can enjoy their rights equally, regardless of their social or economic background. This provides the legal foundation for affirmative action like reservation, as it allows the state to make special provisions for disadvantaged groups to bring them onto a level playing field. Okay. So this is what you need to know. However, Article 14 forbids class legislation but permits reasonable classification. For a law to treat different groups differently, it must pass a twin test established by the Supreme Court. The first is intelligible differentials. That is, there must be a clear logical distinction between the group being treated differently. Clear hona chahiye. Second, rational nexus. The distinction must have direct link to the objective the law is trying to achieve. Direct link hona chahiye. So these two are the test put forth by Supreme Court, Honorable Supreme Court. And Article 15, prohibition of discrimination on certain grounds. So the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, or place of birth. The word only means that discrimination on the other grounds is not prohibited. Okay. No citizen shall be prohibited from using general public use properties maintained partly. This is again a trap. Partly or fully, both are covered by state funds. Since polity deals with laws and statutes, and one word can change the entire meaning, so we will be reading everything very carefully. This provision prohibits discrimination both by the state and by private individual, as we had discussed. Exceptions are also there. The state is permitted to make special provisions for women, children, socially and educationally backward classes of citizens in educational institutions, economically weaker sections, scheduled caste and scheduled tribe. And with this, they provide various amenities and special benefits. So, for example, if you are traveling from buses and there is a concession for women, or there is a rebate, or the bus service is free, how it is happening? These are special provisions or affirmative actions that are done. They are coming because of Article 15 of Indian Constitution. And when we will read DPSP, then we will further understand that how our Indian Constitution empowers the state to work for the people. Article 16, equality of opportunity in public employment. This is specifically for public employment. So it provides for equality of opportunity for all citizens in matter of employment or appointment to any office under the state. No discrimination for employment under the state on grounds only of religion, race, caste, sex, descent, and place of birth or residence. Exceptions are also there. Parliament can prescribe residence as a condition for certain employment in a state, union territory, or local territory. Can be done. Reservation of appointment or post in favor of any backward class that is not adequately presented. And the 103rd Amendment Act of 2019 provided 10% reservation to EWS in civil post and services under the Government of India. Why civil post? In military, there is no reservation. Okay. Now, coming to Article 17, abolition of untouchability, it is present against both the public and the private individual. It abolishes untouchability and forbids its practice in any form. The term untouchability has not been defined in either constitution or in any act. The things which I am highlighting now, what you can do is you can, while I am delivering the lecture, you can keep a 1 A4 size paper and write just these points, which I am telling that this can become a prelims question. If you do this now, last 2-3 days, you can revise them and it will really help you. I can tell you. You will come and message me, sir, it helped me immensely. The Supreme Court held that the right under Article 17 is unavailable against private individual, not just against the state. Okay, is available against private individuals, not just against the state, as I reiterated in the first circumstances only. Now, abolition of titles. So prohibits the state from conferring any title except a military or academic distinctions on anybody, whether a citizen or a foreigner. Prohibits a citizen of India from accepting any title from any foreign state. This is very, very important. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the president. Write it. Consent of president, if it is there, they can accept it. No citizen or foreigner holding any office of profit or trust under the state is to accept any present emolument or office from or under any foreign state without the consent of the president. The Supreme Court upheld the constitutional validity of national awards, Bharat Ratna, Padma Bhushan, and Padma Shri. Okay. Then we have right to freedom, that is Article 19 to 22. And currently we have 6 fundamental freedoms. One is right to freedom of speech and expression, then right to assemble. peaceably and without the arms, right to form associations, union or cooperatives, societies, right to move freely throughout the territory of India, right to reside and settle any part of the territory of India, right to practice any profession or to carry on any occupation, trade or business. The right to acquire, hold and dispose of property was deleted by the 44th Amendment Act of 1978. Now, right to property is one area from where UPSC had asked question multiple times. In the last 5-6 years only they have asked it, and in the last 20 years also we will see this is a repeated and favorite thing of UPSC. Now, if you see initially it was 19 clause 1F May, this was included. Now, post-independence, what happened was the government wanted to implement land reforms. You all know, okay? Abolishing the zamindari system, just so they can redistribute lands to people. Now, every time the government tried to take land for the public good, property owners went to court citing the Article 31. Since this led to a series of famous face-offs between the parliament and the judiciary, it resulted in many amendments. First Amendment, 4, 7, 25th, 42nd Amendment Act. The turning point was 44th Amendment Act. They deleted altogether the Article 19(1) Clause F and Article 31 from Part 3, Fundamental Rights. They inserted a new Article 300 Clause 1 in Part 12. Now, current status is the right to property is no longer a fundamental right, but it remains a constitutional right. No writ jurisdiction can be used in the Supreme Court under Article 32, though they can still go to High Court under Article 226. The state can still take your land, but it cannot do so by an executive order. It must pass a specific law to do it. Unlike fundamental rights, the Constitution no longer mandates market value compensation under Article 300 Clause A, except in two specific cases. First, when the state acquires land belonging to minority educational institutions. Second, when the state acquires land held by person under personal cultivation within statutory ceiling limits. Now, your question will be, is it available, sir, for foreigners as well? Is it only available to the citizen or it is also available to the foreigners? Now, this has been already asked by UPSC, so it is a valid question and it is a very, very important question for your prelims examination. And what I will advise you is pause it and type what will be the answer. That is something which is important for exam. Already asked. Only it has been asked in the PYQs. If you have done PYQs well, you can be able to answer it. Now, the state can impose reasonable restrictions on all 6 rights. For example, Section 144 of the Code of Criminal Procedure can restrain any assembly or meeting if there is a risk of obstruction, annoyance, or danger to human life, health, or safety. All the three. Okay, human life, health, or safety. Then we have Article 20, protection in respect of conviction for offences. It grants protection against arbitrary and excessive punishment to an accused person. Arbitrary means without following the rules and procedures. Excessive means excess than what is prescribed to an accused person, not convicted already, whether citizen, foreigner, or legal person, anyone. Okay. Now, your Article 300A says no person shall be deprived of his property save by authority of law. Supreme Court has already said that I think in 2024, it protects everyone, including non-citizens, foreigners, and even juristic person like corporation. Okay, so read this and then answer. That's important. That's why I'm coming again and again. In polity also, there are 30% area from where 70% question comes, and there I will pause. No ex post facto law. No person shall be convicted of any offense except for violence of a law in force at that time of the commission of the act. It's not like retrospectively they will increase the quantum of punishment or anything. At the time of they have committed the crime, if there existed a law where there was a certain procedure and quantum of punishment was decided, that only will be applicable, nor subjected to a penalty greater than that prescribed by the law enforced at the time of the act. This limitation applies only to criminal laws and not to civil laws or tax laws. Tax laws, we can go retrospective and it has been done many a times. No double jeopardy. That means no person shall be prosecuted and punished for the same offense more than once. Protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal, not for administrative courts. Then no self-incrimination. No person accused of any offense shall be compelled to be a witness against himself. This protection extends to both oral evidences and documentary evidence. However, it does not extend to compulsory production of material objects, compulsion to give thumb impression, specimen signature, and blood specimens, compulsory exhibition of the body. Further, it extends only to criminal proceedings and not to civil proceedings. This is very, very important. Majority of these provisions are valid only for the criminal proceedings. Now, the most widest of all the article is Article 21. Now, before that, I want to explain you one concept. You must have heard a concept called as principle of natural justice. Now, this has been asked by UPSC many a times, and that is why I want to go a bit deeper into it. What is the principle of natural justice and how it is? Is it part of rule of law, or it is something more wider than the principle of justice? What is the difference between the rule of law and rule of man? We read now Article 14, equality before law and equal protection of law. Now, from where it stems from? It stems from rule of law. Previously, when there were kings, so they can punish anybody based on their whims and fancies. Now, the law requires that one cannot treat anybody based on the whims and fancies, and there should be equal protection of law and right to equality before law. This came because of the rule of law. And this is a cornerstone of democracy. If there is no rule of law, there cannot be any fulfilling democracy. That's very, very important to know. Now, A.K. Gopalan case in 1950, the Supreme Court took a narrower interpretation. It held that protection under Article 21 is available only against arbitrary executive action and not against arbitrary legislative action. Okay. Now, what does it mean? That it is only against arbitrary executive action, not against arbitrary legislative action. Now, what is the difference between the executive and the legislature? So, executive is that you see the cabinet. Cabinet is part of executive. Prime Minister is part of executive. And there also we have permanent executive and we have temporary executives as well. Permanent is your all the bureaucracy, not just civil services, but the entire bureaucracy. So it is providing you the protection against arbitrary action of executive only, not legislatures. Now, I was discussing what principle of natural justice. I paused because of a reason so that you can think about it. So principle of natural justice is a set of, you can say, rules of fairness. It should be followed while taking any decision that affects the rights, interest, or legitimate expectations of a person in a democracy. So it is like the action cannot be based on biases. There should be right to a fair hearing. There should be a reasoned decision making. Okay, so it encompasses what is there in the rule of law. Okay, this has been asked by UPSC already. That's why now I am stressing on it. Okay, and natural justice complements constitutional articles like Article 14, 19, 21. Okay, in democracy, the government is accountable to the people. So these principles helps prevent arbitrariness and abuse of power. Citizen must be informed of adverse action and given a reasonable chance to respond. Decision makers must be impartial. Okay. So, and this word doesn't appear anywhere in the Constitution. If UPSC is writing that it is mentioned in the Constitution, then it is wrong. Then we have another case, that is Menka Gandhi case, 1978. Supreme Court took a wider interpretation. It ruled that the right to life and personal liberty of a person can be deprived by law, provided the procedure prescribed by that law is reasonable, fair, and just. Here came the natural justice. Reasonable, fair, and just. It introduced the American expression due process of law. Now, there is two things. One is called as procedure established by law, and other is due process of law. Now, what is the difference between the due process of law and the procedure established by law? So procedure established by law is that the state can take away someone's life or personal liberty only if there is a law and it is followed exactly as prescribed. Okay. But due process of law says that means the law itself must be fair, just, and reasonable. Merely following the procedure which is given in the law is not just. The procedure must also be fair. So now the Supreme Court can strike down a law even if it was duly enacted and duly enacted, and if it is arbitrary or violates the fundamental right or justice. So the Indian Constitution uses the procedure established by law in Article 21 in the Menka Gandhi versus Union of India case. So now India practically follows the procedure established by law and due process of law, mix of both. Earlier only we have procedure established by law, due process of law goes far beyond that. Then we have many of the things which were pronounced by the Honorable Supreme Court under the umbrella of Article 21. So they said that the right to life includes the right to live with human dignity, not mere animal survival. Right to marry is protected under Article 21, and it has been asked by Prelims in 2019. Right to privacy is a part of the right to life and personal liberty implied in Article 21 in the Justice K.S. Puttaswamy case, asked multiple times by the UPSC. Not only that, we have Article 21 has lot of rights. One is like right to shelter. Okay. Right to shelter is also part of right to sleep at the night. And there is a famous case that happened with respect to Baba Ramdev, and that led to a lot of pronouncement. So one of that was this as well. And there are lot many things under Article 21 umbrella. Then we have Article 21A that the state shall provide free and compulsory education to all children between the age of 6 to 14 years. The right is also involved in the DPSP, Article 45, and in Fundamental Duties, Article 51A. Then comes the Article 22, protection against arrest and detention. Detain karna. Article 22 grants protection to person under both kinds of detention, punitive and preventive. So punitive detention is to punish a person for an offense committed by him after trial and conviction in a court. Preventive detention is of a person that they seen as someone who is detention without trial and conviction, but they perceive as a threat. Okay, for maybe against the law and order or anything it can be. Okay, it can be anything, means it should be directly threatening the law and order. That has to be there. Okay, or waging war against the state. Those things, in those scenario only. And for that, we have legislations as well that has been enacted. So rights upon arrest, punitive detention, we have right to be informed of the ground of the arrest, why you are arrested, that has to be said. Second, right to consult and be defended by a lawyer of his choice, that is your right. Right to be produced before a magistrate within 24 hours of arrest, excluding time of journey. Then right not to be detained beyond 24 hours without the authority of a magistrate. Now these rights are not available to enemy, aliens, or to person detained under preventive detention laws. Now what is there for preventive detention then? If detention is for more than 3 months, the matter must be referred to an advisory board, which must include a High Court judge. Second, the detention may be continued only where the advisory board considers there are sufficient grounds for further detention. Then grounds of detention must be communicated to the detainee, and the detainee must be given an opportunity to make a representation against the order of detention. These are the things which are there. You must have heard about laws like NSA, etc. Then the special provisions comes into the picture, and this has been also asked in the PYQs by UPSC. Nothing I am including is not something which is not hot important. So that is why these videos are very, very important for you. Then we have right against exploitation, Article 23 and 24. So 23 is a prohibition of traffic in human beings and forced labor. This right is available to both citizens and non-citizens. It protects the individual not only against state but also the private persons. It permits the state to impose compulsory service for public purposes such as military services or social services, which cannot be said to be a forced labor. Article 24, prohibition of employment of children in factories. It prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activity. It does not prohibit their employment in any harmless or non-hazardous work. Okay. So if they are working in any harmless or non-hazardous work, it is not prohibited. Then we have right to freedom of religion, Article 25 to 28. Article 25 gives the freedom of conscience and free profession and practice and propagation of religion. So all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. It does not include a right to convert another person to one's own religion. Okay, forced conversion is not allowed in Constitution. Article 26, freedom to manage religious affairs. That is a right of group or religious denomination. Here it is about individuals also. Okay. So rights of religious denomination to establish and maintain institutions for religious and charitable purpose, to manage its own affairs in matter of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. Then comes Article 27, which is freedom for taxation for promotion of religion. So no person shall be compelled to pay any tax for the promotion or maintenance of any particular religion or religious denomination. The state should not spend public money collected by way of tax for promotion of any religion. No tax, but fee can be levied. Fee can be levied. Tax cannot be levied, fee can be levied. Yeah, these are word plays. That's why it's called as lawyer's paradise. Article 28. Freedom from attending religious instruction. Now, no religious instruction shall be provided in any educational institution wholly maintained out of state funds. Your totally maintained state government school. This does not apply to educational institution administered by the state, but established under an endowment or trust acquiring the imparting of religious instruction. So it will not apply to them. Okay. Then comes the cultural and educational rights. So Article 29, protection of interest of minorities. Any section of the citizen residing in any part of India having distinct language, script or culture of its own shall have the right to conserve the same. This right is available to every citizen, including both minorities and the majority as well. So it's not that it's just for the minority, it's for majority also. If you have a distinct language, script or culture of its own, they have the right to conserve the same. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds or grounds only of religion, race, caste, or language. Only whenever it will come, that means other grounds can be applied. Article 30, rights of minorities to establish and administer educational institutions. So all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. The right is available only to minorities, not to the majority. So this is only available to minority, not to the majority. The compensation amount fixed by the state for compulsory acquisition of property of a minority educational institution must be such that it does not restrict the right guaranteed under Article 30, 44th Amendment. Okay. The term minority is not defined in the constitution. Okay, that's very, very important. Come to the right to property. So that we read in detail before only. Article 31, agriculture reform, industry, commerce. The state can acquire personal land. Laws providing for acquisition of states and related rights are protected from challenge on grounds of violation of Article 14 and 19. 31B, acts and regulations specified in the 9th schedule are protected from being challenged on the grounds of violation of fundamental rights. Lekin, IR Coelho case 2007, the Supreme Court ruled out blanket immunity. Acts placed in the 9th schedule after 24th April 1973 can be challenged if they violate the basic structure. क्योंकि basic structure आ चुका था. Article 31C, laws to implement directive principle under Article 39B and C are immune from challenges on grounds of violation of fundamental rights. Why so? You will understand when I will go back again. Why it is so? Okay. No law containing a declaration that it is for giving effect to such policy shall be questioned in court on the ground that it does not give effect to such policy. This second provision was declared unconstitutional and void by the Supreme Court in Kesavananda Bharati case. Now we have right to constitutional remedies, that is Article 32. So Article 32 is itself a fundamental right and the basic feature of the Constitution. The President can suspend the right to move any court for enforcement of fundamental rights during a national emergency, Article 359. Article 32 is used only for the enforcement of fundamental rights, not for other rights. Parliament can empower any other court to issue direction, orders, or writs. This is something very important. Parliament can empower any other court. They can say, okay, this court is also have the power to issue direction, orders, or writs. Now, let's compare the right which is available under Article 32 and 226, Supreme Court versus High Court. Let's see. So jurisdiction can issue writs for fundamental rights only, not for other rights. However, High Court can issue writs for fundamental rights as well as other legal rights. It is narrow, it is wider. Territorial scope can issue writs against bodies throughout the country. However, it can issue writs only against bodies within that state's territory. Narrower territorial jurisdiction is there. Now, Article 32 is itself a fundamental right. The Supreme Court cannot refuse to exercise writ jurisdiction. Article 226 is a discretionary. The High Court may refuse in appropriate cases. Yeah, it is their duty, the Honorable Supreme Court. Now, there are types of writs. So there is habeas corpus, means to have the body. Whenever a person is detained under punitive detention issued by the court to a person who has detained another person to produce the body of the latter before the court, can be issued against public authorities as well as the private individuals as well, habeas corpus. Lawful detention cannot be issued against. Lawful detention, contempt of court. Okay, it cannot be issued against. Mandamus, that is we command to any public official to perform their duty. If they are not performing, asking him to perform official duty that he has failed or refused to perform, issued only against judicial and quasi-judicial authorities. So it cannot be issued against private body, the president, the Chief Justice of India in his judicial capacity. It cannot be issued. Then we have prohibition. So it is to forbid. So issued by a higher court to a lower court to prevent it from exceeding its jurisdiction. Okay. But it cannot be issued against administrative authorities, legislative bodies, and private individuals. Then we have certiorari. The certiorari is to be certified or to be informed. It is for transferring a case from a lower court to a higher court. Okay. So issued by a higher court to a lower court or tribunal, either to transfer a case pending with it or to quash its order in a case, both preventive and curative in nature. It can be preventive as well. It can be curative as well. Legislative bodies and private individuals against this cannot be done. Then we have क्यों वारंटो, means आपकी authority क्या, by what authority or warrant to inquire into the legality of a person's claim to a public office. So issued by court to inquire into the legality of claim of a person to public office only in a case of substantive public office of permanent character created by the statute of the Constitution. It cannot be issued against ministerial office or private office. Okay, so this is your fundamental right का chapter complete. अब आते हैं to DPSP, Directive Principle of State Policy, another very, very important. Now, Directive Principle of State Policy are very, very important, but it wasn't given the same kind of status as fundamental rights. Why so? So because see, our country was a developing country. We did not had enough resources. So rather than forcing onto the state, it was sort of made like an enabling provisions. And now if you see the laws that are made, majority of the laws that are made in terms of, say for example, Maternity Benefit Act, or the protection for or the welfare of senior citizens, or transgenders act, anything that is being provided, even child care. Now, all of this stems from DPSP only. Okay, so the majority of the policies that you are seeing are nothing but they are trying to deliver what is written in the Directive Principle of State Policy. And this idea is borrowed from the Irish Constitution of 1937. It embodies the concept of welfare state and not that of a police state. Okay, of a welfare state, not a police state. Police state, we'll talk just about law and violation and this and that. The directive principles are non-justiciable in nature because of the reason I told you. They can help the court in examining, determining the constitutional validity of law, but not enforceable like the fundamental rights. Directive principles do not constitute limitations upon legislative or executive function. They are guidelines to the state. They are enabling provisions. Article 36 defines the term state, same as Article 12 for fundamental rights purpose. Article 37, it shall be the duty of the state to apply these principles in making laws. Here comes the major thing. Article 37 is saying that it shall be the duty of the state to apply these principles in making law. It's very, very important. That's the heart and soul. Now let's see. We have socialistic directive principles, Gandhian directive principle, liberal intellectual directive principle. Socialistic principle, Article 38, create a social order for promotion of welfare of now and minimize inequalities in income, status, facilities, and opportunities. Okay. Article 40 is Gandhian, based on Gandhian principles to organize village panchayats, and we have done it. Liberal intellectual directive principle, your uniform civil code, Article 44. This is very important. So our uniform civil code does not delve into the religious spectrum. It is dealing with the secular perspective of the things which are dealt by the religious laws, like marriage, adoption. And these are not religious, meddling into religious affairs. So the difference should be known to you. Then we have Article 39A, that is adequate livelihood for all. Now the BC, equitable distribution of resources for common good. That cannot be nullified. That's very, very important. Equitable, because we have a country with humongous inequality, historical inequality. Then prevent concentration of wealth in few hands, 1% having 73% property. D is equal pay for equal work for men and women, to have gender inequality. Then we have protect health of workers and children. And the F clause is healthy development of children, 42nd Amendment. Now these DPSPs are gold mines to write in your mains answer. Very important. Very important. I can tell you, if you use DPSP, plus 5 marks in your GS2. Note it down. Gandhian principle, Article 43, promote cottage industry. He wanted to have, he used to give a lot of importance to the village economy. Article 45 is based on liberal intellectual principle. Provision for free and compulsory education for children till the age of 14 years, modified by 86th Amendment Act 2002. Now a fundamental right under Article 21A as well. Then in socialism, Article 39A, equal justice and free legal aid. NALSA has been made because of it. In Gandhian principle, promotion of cooperative societies, 97th Amendment Act 2011. Intellectual principle, Article 48, organization of agriculture and animal husbandry on modern and scientific lines. Your ENAM. What is it? It is trying to fulfill Article 48. Article 41, based on socialism, right to work, to education, and to public assistance in certain cases. In socialism itself, Article 42, provision for just and human condition of work and maternity relief. Your Maternity Benefit Act comes from here. Article 43, ensuring living wage and decent standard of life for workers. Article 43A, participation of workers in management of industries. Here your unions are there, trade unions, etc. Article 47, raise level of nutrition standard of public health. Your schemes like Ayushman Bharat, etc. is to ensure. Article 47. In Gandhian principle, Article 46, promote educational and economic interests of scheduled caste and scheduled tribes. Article 47, prohibition of intoxicating drinks and drugs injurious to health, raise level of nutrition and standard of living. Okay. यहाँ से ना your prohibition in Bihar, Gujarat, etc. comes. In Article 48, prohibits slaughter of cows, calves, and other milch and draught cattle. Many of the states have made law with respect to it. An intellectual and liberal principle, Article 48A, safeguard forest and wildlife. So your Wildlife Protection Act, your Environmental Protection Act, your NGT, etc. tries to fulfill this. And Article 49, preserves monuments of historical or national importance. And you have Dekho Apna Desh, and there are so many initiatives to preserve our monuments. Article 50, Swadesh Darshan scheme. Article 50, separate the judiciary from the executive in public services. Your NJSC was strike down because of it also. Article 51, promote international peace and security. That is what India strives for. Now note, the common agreement between Gandhism and Marxism is that the final goal of a stateless society asked in PYQ. This can be inferred from the Gandhian directive principle. Article 39B and C are the most litigated directive principle. They deal with equitable distribution of resources and prevention of concentration of wealth that we read also previously. Now, conflict between fundamental rights and DPSP. So there was a case called a Champakan, the Dorai Rajan case in 1951. In that, court said that fundamental rights prevail over DPSP, but fundamental rights can be amended. Golaknath case, 1967, fundamental rights cannot be amended even for implementing directive principle. Fundamental rights are sacrosanct according to Golaknath case. 24th Constitutional Amendment. Parliament has the power to abridge or take away any fundamental right under Article 368. So Parliament has the power to abridge or take away any fundamental right under Article 368. Then comes 25th Constitutional Amendment. Article 31C was inserted for implementation of DPSP 39B and C. Fundamental rights can be amended, cannot be challenged in court. Then Kesavananda Bharati case, 1973. Upheld the 24th Amendment, overruled Golaknath, cancelled the second provision of Article 31C. Court review cannot be ousted, which we read previously. Laid down the doctrine of basic structure of doctrine, Atma, soul of Constitution. 42nd Constitutional Amendment Act 1976, directive principles made superior to fundamental rights for a wide range of directive principles, not just 39B and 39C. Minerva Mill case 1980, fundamental rights is superior to DPSP. However, directive principle 39B and C prevails over Articles 14 and 19. Judicial review is basic structure of the Constitution. The current status is that these are two wheels of the same cart. We have to go together. Okay. It's not that one can be just abridging anything without any application of law. However, the status remains same for the 39B and 39C. And the reason because of the content that is there. Fundamental duties wasn't present when the original constitution was framed. It was inspired from Soviet constitution, and 1976 there was a Sorensen committee recommended inclusion of fundamental duties in the constitution. 1999 the Pharma committee identified legal provisions for enforcement of fundamental duties. 42nd Constitutional Amendment Act 1976 included 10 fundamental duties in Part 4A and Article 51A. The 11th fundamental duty was added in by the 86th Constitutional Amendment Act 2002. Fundamental duties are confined to citizens only, not to foreigners. They are non-justiciable. No legislative process has been provided for the enforcement. Voting in public election is not a fundamental duty. What all are there? 1. Respect the national flag and the national anthem. 2nd, follow the noble ideas that inspire the national struggle for freedom. Third, protect the sovereignty, unity, and integrity of India. Fourth, defend the country and render national service when called upon. So, fifth, promote harmony and the spirit of common brotherhood amongst all the people of India. Sixth, preserve the rich heritage of the nation's composite culture. Seventh, protect and improve the natural environment, including forest, lakes, rivers, and wildlife, and have compassion for living creatures. Eighth is develop scientific temper, humanism, and the spirit of inquiring freedom. That means witchcraft, etc., cannot be permitted. Ninth, safeguard public property and abjure violence. 10th, strive towards excellence in all spheres of individual and collective activity. 11th, provide opportunities for education to a child between the age of 6 and 14 years, added by 86th Amendment Act 2002. Now, the Swaran Singh Committee recommended originally how many fundamental duties? That's your question. Pause it and answer it. It's important. Okay. Your prelims focus, these are provided for your last 3-4 days revision. I have already provided it. Sun Singh Committee had recommended 8 fundamental duties. Okay. What all were there? Please write in comment box. Amendment of the Constitution. So Article 368 in your Part 20 of the Constitution deals with the powers of Parliament to amend the Constitution and its procedure. Indian Constitution is neither flexible nor rigid, we know that. Parliament cannot amend those provisions which are in basic structure doctrine. Key procedural points, the bill can be initiated in either House of Parliament. It can be initiated by a minister or private member. Does not require the prior permission of the president. It must be passed by special majority more than 50. These are like it's all together written in one area, but we will read the classification, then we will understand what is applicable when. What is applicable when is then we will understand. So for simple majority of parliament outside the scope of Article 368, addition of new states, alteration of name, addition of new states, if it is done, it can be done with simple majority. Alteration of names, areas, or boundaries of state, like Kerala. Kerala became Kerala. Formation of legislative councils. Second schedule, citizenship. Fifth and sixth schedule, official languages, elections to parliament and state legislatures. Then special majority of parliament, more than 50% of total membership and 2/3 present and voting. It is needed for fundamental rights, the active principle of state policy, and all other provisions not covered by the first or third categories. Then special majority of parliament and ratification by half of state. That's the most rigid. By simple majority, by half of state by simple majority. That is for election of the president, extent of executive power of union and states, Supreme Court and High Courts, distribution of legislative power between union and states, goods and services tax, council, GST council, any of the list in the 7th schedule, representation of states in parliament, Article 368 itself, basically trying to protect the federalism, federal structure. Basic structure of the constitution. So Shankari Prasad case 1951. What happened was First Amendment Act 1951. It was challenged. Supreme Court held that the power to amend the constitution also means power to amend fundamental rights. The word law in Article 13 includes only ordinary laws, not constitutional amendment acts. Okay. Then came the Golaknath case. Supreme Court ruled that fundamental rights are given a transcendental immutable, that is, they are sacrosanct. 24th constitutional amendment that we read only, Kesavananda Bharati, okay, Doctrine of Basic Structure. Previously also we read. Minerva, Supreme Court struck down the clause introduced by the 42nd Amendment that removed all limitation, held the judicial review is basic structure of the Constitution. Because 42nd Amendment, what they did, they sought to remove all limitation of Parliament amending power and declare no court could question amendments. That's like establishing the parliamentary supremacy or sovereignty. Okay. What all basic elements are there in basic structure? Supremacy of the constitution, sovereign, democratic and republican nature of the Indian polity, secular character of the constitution, separation of power between the legislature, the executive and the judiciary, federal character of the constitution, unity and integrity of the nation, welfare state, judicial review, freedom and dignity of the individual, parliamentary system, rule of law, fundamental rights. All are part of basic structure doctrine. Then your parliamentary system and federal system. So features of the parliamentary system. Now, the parliamentary system is the one in which the executive is responsible to the legislature for its policies and act. Your council of ministry is responsible to it. Yeah. The president is a nominal executive, the prime minister is real executive. The political party that secures a majority in Lok Sabha forms the government. Ministers are collectively responsible to parliament in general and Lok Sabha in particular under the Article 75. Political homogeneity. Okay. The Council of Ministers belong to the same political party and share the same political ideology. How this depends. Now, ideologies, etc. It depends. A coalition में कहाँ से there will be ideology. Okay, so it's not mentioned in the constitution. It's a general thing. Ministers are member of both the legislature and the executive, unlike the presidential system. Okay. Minister operate on the principle of secrecy of procedure. That's very, very important. Lok Sabha can be dissolved by the president on the recommendation of the prime minister. The shadow cabinet is a unique institution of British cabinet system. वहाँ क्या होता है? If a finance minister of party is there, then opposition का भी finance minister will be there. To have checks and balances, more checks and balance. Every ministry is under check. Then there are two systems: federal versus unitary government. Federal means there will be dual government and there will be national and state governments. And in federal government, we have written constitution, so there is a division of power, which is not so present in the unitary form of government. Here, the no rigid constitution is the supremacy of constitution, independent judiciary, and bicameral legislatures. However, in the unitary government, we can have constitution may be rigid and flexible, and we have mix in India. Constitution may be supreme Japan or may not be supreme. Judiciary may or may not be independent. Legislature may be bicameral or unicameral like China. Okay. Term federation has nowhere been used in the constitution. Article 1 describes India as the union of state. Federation term is nowhere mentioned in the Indian constitution. बन गया है question. Indian federalism is not the result of an agreement among the states. Unlike the American federation, it can be altered by the parliament. The Indian federal system is based on the Canadian model and not on the American model. And your center-state relations or legislative relations are given under Article 245 to Article 255. There is a threefold distribution in the 7th schedule. There is union list, state list, and concurrent list. Parliament make laws for whole India. State laws limited to that state. Parliament can make laws on state list under 5 special circumstances. 1. Rajya Sabha resolution by 2/3 majority during national emergency, and 2 or more states request Parliament for implementing international treaties. 5th, when president rule is imposed in a state, the 42nd Amendment Act transferred 5 subjects to the concurrent list from the state list. That is education, forest, weights and measures, protection of wild animals and birds, and administration of justice. Residuary power always will vest with the parliament. This is important part, very important. Administrative relations, so which is given in Article 256 to Article 263 in Part 11 of the Indian Constitution. Executive power divided on the lines of legislative power. Every state must exercise executive power to ensure compliance with central laws. The center can give direction to state on maintenance of means of communication, protection of railways, adequate facilities for instruction in the mother tongue at the primary stage, execution of scheme for welfare of scheduled castes and tribes, not caste. Under Article 356, if a state fails to comply with central direction, president rule can be imposed. Article 356. Financial relation, Article 268 to 293 in Part 12. So Parliament has exclusive power to levy taxes on union list subject, state legislature on state list subject. Residuary power of taxation remains with the Parliament. Now, key tax distribution under Article 268, tax levied by center collected and appropriated by states like stamp duties. Article 269, tax levied and collected by center but assigned to states like interstate sales tax. Article 269A, goods and services tax in interstate trade. Article 270, tax levied and collected by center but distributed between center and states. Article 271, surcharge by the center, grant in its. Article 275, statutory grants to needy states. Article 282, discretionary grant. Finance Commission. Okay. Article 280 recommends distribution of tax revenues. These all are related to it. Then we have emergency provisions. Article, we have 352, 356, and 360. The first is called as national emergency. The second is called as president rule, and third is called as financial emergency. Now, grounds. So, national emergency can be applied only on the ground of external aggression or armed rebellion. 44th Amendment changed the internal disturbance to armed rebellion to make it more rigid. The 42nd Amendment allowed the president to limit operations to even a particular area. Also, national emergency can be applied. President rule is also known as state emergency or constitutional emergency. So, Article 356, president satisfied with or without governor reports. With or without governor reports. On its own, president on its own is, acts on advice. That the government of a state cannot be carried on accordance with the constitution. Article 365 states fail to comply with the direction of the center. Financial emergency, Article 360, President satisfied that the financial stability or credit of India or any part thereof is threatened. Then they can apply. Proclamation, so national emergency, President only after receiving a written recommendation from the Cabinet Council of Ministers headed by Prime Minister. 44th Amendment Act requirement. Previously, it was not there. In terms of your President rule, President on the basis of governor's report or otherwise also he can do. And financial emergency, President can do. Parliamentary approval. So national emergency must be approved by both the houses within 1 month from the date of issue. If approved, continues for 6 months, can be extended indefinitely with approval for every 6 months. Periodic parliamentary approval is needed. 44th Amendment approval for continuation requires special majority in the either house. Now, the President rule must be approved by both houses within 2 months from date of issue. If approved, continued for 6 months, can be extended for a maximum of 3 years with approval of Parliament every 6 months. Simple majority for continuation. Condition for continuance beyond 1 year is also given. National emergency in whole country or election commission certifies that holding general election is difficult. Financial emergency must be approved by both the house within 2 months. If approved, continues indefinitely until revoked. Simple majority for continuation, no maximum period specified. Revocation, President must revoke if Lok Sabha passes a resolution by simple majority. 1/10 of total members of Lok Sabha gives a written notice to Speaker. 44th Amendment Act. Governor rule, President can revoke at any time, no parliamentary approval needed, and President can remove the same way financial emergency as well. Judicial review, proclamation brought under judicial review, proclamation can be challenged in court. No specific case law to the contrary. So financial emergency, no, not particular cases are there. Effects of national emergency on fundamental right. Okay. Article 358 automatically suspends the 6 rights under Article 19, but only when the national emergency is declared on grounds of external aggression, not on grounds of armed rebellion. Only on grounds of external aggression, not on the armed rebellion. The suspension applies for the entire duration of emergency and to the entire country. The 44th Amendment Act restricted automatic suspension to external aggression only. That was done later on only. Article 359, President may by order suspend the right to move any court for enforcement of the fundamental rights except Article 20 and 21. These can never be suspended even during emergency. Applies in both cases, external aggression, armed rebellion. The President may specify duration and geographical extent, may apply to the entire country or may apply to the any part of it. It's very important. Then comes your President and Governor. Let's have a comparison. So the election of President by a member of Electoral College, that includes elected member of both Lok Sabha and Rajya Sabha, elected members of state legislatures, elected members of Union Territory legislatures of Delhi and Puducherry. Vote value of MLA is equal to total population of state divided by number of elected members into 1000. Vote value of MP is equal to total value of all MLA divided by total number of elected members of Lok Sabha and Rajya Sabha. Proportional representation by single transferable vote with secret ballot is allowed. Governor, though, appointed by the President by a warrant under his hand and seal. The governor is center's nominee, but an independent constitutional office as well. It has dual role to play. Based on the Canadian model of appointment, the Sarkaria Commission recommended that the governor should belong to a state other than the one he is appointed to. This is a convention, not a constitutional provision, so that he is not biased. Qualification. So he should be citizen of India, complete 35 years of age, qualified to be a member of Lok Sabha, not a member of either house, no office of profit. In terms of governor, citizen of India, complete 35 years of age, not a member of either house, no office of profit. Oath. So in terms of President, administered by the Chief Justice of India. In terms of your governor, administered by the Chief Justice of the concerned High Court. Term, 5 years, eligible for reappointment any number of times, can resign by addressing the Vice President. Why it is mentioned? Because in America, we have only 2 times a President can be appointed. Governor, 5 years, subject to the pleasure of the President, can be removed any time. That means no security of tenure, can be transferred by the President, can be appointed in the same state. Chief Justice of the High Court may be appointed temporarily if the governor's office is vacant. Removal. Impeachment for violation of the Constitution initiated by either house, signed by 1/4 of the member with 14 days notice to the President. Resolution passed with special majority by both houses. Elected and nominated members of Lok Sabha and Rajya Sabha participates. No member from state legislatures. In governor, removal of the president at pleasure, no ground specified in the constitution for removal. Under BP single case 2010, removal cannot be arbitrary, capricious, or for political reason was given. Emoluments cannot be dismissed during term, cannot be dismissed during term. The powers of the president. So executive power of the union is vested in the president. He makes rules for transaction of government business. He appoints the prime minister, council of minister, attorney general, comptroller and auditor general, governor, etc. He can declare any area a scheduled area. He summons, prorogues, and dissolves Lok Sabha, nominates 12 members to Rajya Sabha, decides disqualifications of member with election commission, issues ordinances, appoints speaker and deputy speaker when office falls vacant. Then financial power, money bills require prior recommendation of the president. He summons parliament to present the union budget. He constitutes the finance commission. Judicial powers, appoints the chief justice of India and other judges of the Supreme Court and High Court, can seek advices from the Supreme Court, grants pardon and commute punishments. A veto power of the president over the bill. Absolute veto, president withholds his assent to a bill, the bill ends. Available for private members' bills, and when the cabinet has resigned after passing the bill, no qualified veto, that is legislatures, cannot override with higher majority. Suspensive veto, president returns the bill to parliament for reconsideration. If parliament passes it again with or without amendments, the president is bound to give the assent. It is not available for money bill. Then pocket veto, this was famously used by ex-president Gyani Jail Singh. President takes no action on the bill, keep it pending for an indefinite period. But it is not available for constitutional amendment bills. Indian pocket veto is wider than the American pocket veto. Now, president's veto over a state bill. A governor has 4 options: give assent, withhold assent, return the bill, other than money bill for reconsideration or reserve it for the president's consideration. If a bill is reserved for the president's consideration, the president has 3 options: give assent, withhold assent, or direct the governor to return the bill to the state legislature. Then there is ordinance making power. So when both houses or either house of parliament are not in session, this can be used. Okay. Governor, when both houses or either houses of the state legislature are not in session. In case of bicameral legislature, when state legislature is not in session, in case of unicameral legislatures. Condition, only when the president is satisfied that circumstances require immediate action. After the 44th Amendment, the satisfaction of the president is subject to judicial review. In case of governor, only when the governor is satisfied that circumstances require immediate action, and 44th Amendment Act also introduced judicial review. Parliamentary approval, when parliament reassembles, both houses must approve the ordinance. If not approved, it expires after 6 weeks from reassembly. Maximum life is equal to 6 months and 6 weeks. Same as president must be approved when legislature reassembles. Other restrictions can only be issued on advice of the Council of Ministers, cannot be issued to amend the Constitution. Ordinance making power is extensive with the Parliament, but not parallel to the Parliament. Okay, it's not a parallel power. In governor, ordinance making power of the governor is not a discretionary power. The president can instruct the governor on ordinance making. The governor cannot issue an ordinance to amend the constitution, obviously. Now, the pardoning power is something in which cases after cases comes. So we will try to gauge it as clearly as possible, but this is something now where you will have a lot of confusions. So what are the, first of all, try to understand the types of mercies. So one is commutation, that is substitution. If a person is given higher punishment, lower can be given. Remission, reducing period without changing character of punishment. Respite, lesser sentence due to special facts like pregnancy, disability, etc. Reprieve, stay on execution for a temporary period. Okay. Same powers, pardon, commute, reprieve, respite, suspend for offenses against state laws. Death sentence, president can pardon death sentence. Now, this is the area, government power for pardoning the death sentence. Supreme Court has held that the governor's pardoning power under Article 161 overrides procedural limit of ordinary law, such as 433A of CRPC, which requires 14 years of jail before omission. Okay. The court has observed that no specific time limit is laid down in the Constitution for deciding mercy petition, but undue delay or inaction can attract judicial intervention under Article 142. Okay. Now the thing is, can governor pardon death sentences? Okay. Now pause it and tell me. Pause it and tell me. Write in the comment box. This is something which is important. And these are areas from where question will come. Okay. This is something which you need to write in the comment box. Recent scenario. Okay. Is it true or not? It is a stand for not. So, nature and executive power independent of the judiciary and executive power independent of the judiciary. Now, discretionary power of the government, it has wider discretionary power compared to the president. Constitutional discretion, reservation of state bills for the president's consideration, recommendation of president rules under Article 356, administration of an adjoining union territory when appointed as such, seeking information from the chief minister regarding administrative and legislative matters. Additional discretion specific case in Maharashtra and Gujarat, establishment of separate developmental boards. Nagaland, Assam, Manipur, Sikkim, Arunachal Pradesh, Karnataka, Mizoram, as specified in the relevant special provisions. So first we will see Rajya Sabha, which is also called as upper house. Fourth schedule of constitution deals with how many seats will be allocated to a individual state or union territory. It is given in fourth schedule. Now the members of Rajya Sabha are elected by the elected members of the state legislative assembly through the system of proportional representation by a single transferable vote. So here elected is specifically mentioned. Seats allocated to states in Rajya Sabha are based on population. Okay, that is why you will see larger states having large number of Rajya Sabha seats, larger population, more Rajya Sabha seats. Now, this is also perhaps debatable as well by many. They say that, okay, Lok Sabha, though, fine, it is based on population. We could have something like Senate having equal representation from each of the state, at least in some areas, giving more or equivocal voices to even the smaller states as well. These are just the viewpoints. Now, representatives of union territories in Rajya Sabha are indirectly elected by members of an electoral college with a system of proportional representation. Only two union territories have representation in Rajya Sabha, Delhi and Puducherry. However, up to Jammu and Kashmir also has Rajya Sabha seats. And after 2019, the newly created union territory of Jammu and Kashmir has representation in Rajya Sabha. Ladakh does not. Okay. This scenario after 2019 change ho gaya. The president nominates 12 members to Rajya Sabha from person with special knowledge of practical experience in literature, science, art, and social service. Then you will say, sir, why Sachin Tendulkar was given? इसको आर्ट में कंसिडर किया गया ना, बैटिंग को भी, बैटिंग इज एन आर्ट. Rajya Sabha is a permanent body. It cannot be dissolved. However, 1/3 of its members retire every 2 years. So that continuity bani rahe. The constitution does not fix the term of Rajya Sabha members. RPA did. Representation of People Act 1951 provided a 6-year term. Again, यहाँ पे लिखा है constitution says that the term should be 6 years. So it's wrong. Lok Sabha has a normal term of 5 years. This can be extended by 1 year at a time during national emergency. Now let's talk about another very important body, that is Speaker. So it is elected by the members of Lok Sabha from among its members. He is the guardian of the power and privileges of members. His decisions on all parliamentary matters is final. And he adjourns the house or suspends the meeting if the required quorum is not maintained. Okay, quorum, the minimum number should be present. He exercises a casting vote only in case of a tie. He cannot vote in the first instances. He presides over a joint sitting of both houses. The deputy speaker presides in his absence. He decides whether bill is money bill. There were subsequent cases also with respect to Aadhaar bill and all. An ordinary bill or an ordinary bill. His decision is final and cannot be questioned in court. But ठीक है, फिर इसको भी court में खींच ही लिया था. Then he decides on disqualification of members on ground of defection under the 10th schedule. After the Ayaram Gayaram famous case, this was something which was done. But again, wholesale defection though is happening. Merger kind of 2/3 members ko leke, if they are merging, then it's happening, and it has been so much misused as well. He is the chairman of the Business Advisory Committee, Rules Committee, and General Purpose Committee. The Speaker can be removed only by a resolution passed by an absolute majority of all then members of Lok Sabha with 14 days notice. The Speaker is at higher rank than all cabinet minister. That's why the respect has to be shown. In India, the Speaker does not resign from his party. In Britain, the Speaker is a non-party person, so that he is neutral. This is also something you will write in suggestion as a way forward to make speaker as a neutral, more neutral. By parliamentary convention, not a constitutional provision, generally the speaker is from ruling party, not given in the constitution, and the deputy speaker is from the opposition party. Just a convention. Party can agree, party in power or not. The Government of India Act of 1919 first provided for the office of president and deputy president or the of the Central Legislative Assembly. वो तो हमने पढ़ा ही था. The Government of India Act of 1935 renamed them as speaker and deputy speaker. However, the old nomenclature continued till 1947 as the federal part of the 1935 Act was not implemented. Now, panel of chairperson and speaker pro tem. So, under the rules of Lok Sabha, the speaker nominates a panel of 10 members. Those are called as panel of chairperson. Any one of them can preside if the office of both the speaker and the deputy speakers are vacant or absent. Speaker pro tem, we had discussed the senior most one. The president appoints a member of Lok Sabha as speaker pro tem temporary to preside over the first sitting of new Lok Sabha until a new speaker is elected. So, with the speaker pro tem. And chairman of Rajya Sabha is the vice president of India. His ex-officio chairman of Rajya Sabha. The chairman can be removed from office only if he is removed from the office of vice president. The chairman is not a member of the house, unlike the speaker, who is a member. The deputy chairman of Rajya Sabha is elected by Rajya Sabha from among its member and can be removed by an absolute majority. Yeah. Then leader of the house and leader of the opposition. So under rules of Lok Sabha, the prime minister is the leader of the house or a minister nominated by the prime minister. In Rajya Sabha, the prime minister nominates a member as minister as a leader of the house. आपने देखा होगा ना, leader of the house होते हैं. That you have, if you have seen the proceedings of Lok Sabha and Rajya Sabha, you must be knowing it. Leader of opposition was recognized for the first time in 1969. It received statutory recognition in 1977. Mentioned in the Salient Allowances of Leaders of Opposition Act. A party must have not less than 1/10. That only was used to deny Mr. Rahul Gandhi to become the leader of opposition once, because 1/10 of total seats in the House to be recognized as the official opposition was not there. Still, they can do it. The leader of the opposition is equivalent to rank to a cabinet minister. The whip is not mentioned in the constitution or in the rules of house. Not in the constitution, not even in the rules of the house. It is based on the parliamentary convention. Then sessions of parliament. So first it is summoned. Who summons it? The president. Session is the period between the first sitting and prorogation. The recess is the period between prorogation and again the reassembly will happen. Then adjournment. Each day's meeting consists of 2 sittings. A sitting is terminated by adjournment. It suspends work for a specific time, like hours, days, weeks. Hours is adjourned till 6 p.m. This can be also done. Then adjournment sine die, terminating a sitting of the House for an indefinite period without naming the day of reassembly. You don't know. So the power lies with the presiding officer. Then prorogation. When the presiding officer declares the House adjournment sine die after the business of session is completed, the president issues a notification of prorogation. Then the dissolution. So only Lok Sabha is subject to dissolution. Rajya Sabha is permanent because had 2 years mein 1/3 of members retire. Then lapsing of bills upon dissolution of Lok Sabha. This is something which makes questions. Probable questions will come. So bills passed by both houses but returned by the president does not lapse. Okay. Bills passed by both houses but pending assent of the president will not lapse. Bill pending in Rajya Sabha but not yet passed by Lok Sabha does not lapse. Bill pending in Lok Sabha wherever originated lapses. Okay, so if bill is pending in Lok Sabha, kahin se bhi originate hua, it lapses. Bill passed by Lok Sabha and pending in Rajya Sabha will also lapse when the dissolution of Lok Sabha will happen. सिर्फ लैप्स वाला याद कर लो, 3 नॉट लैप्स नहीं करने की जरूरत पड़ेगी. These 2 just cram it. That's it. हो जाएगा काम. Then parliamentary motions. So no confidence available only in Lok Sabha. Ministers के against you can do it. Require support of at least 50 members to be admitted. No reasons need to be stated. If passed, the entire council of ministers must resign. First introduced in 1963 by Acharya J.B. Kripalani against the Nehru government. Then comes censor motion. Here, reason must be stated for adoption and can be moved against an individual minister or a group of ministers or the entire council. If passed, the council of minister does not necessarily have to resign. So this is more powerful, no confidence motion. Then adjournment motion. So it is available only Lok Sabha. Rajya Sabha is not permitted to use it. An extraordinary device, as it interrupts the normal business of the House, requires support of 50 members. Discussion must last at least 2.5 hours, can only raise a matter that is definite, factual, urgent, and of public importance. Then comes calling attention motion. So calling attention motion is available in both the houses. To call the attention of minister to a matter of urgent public importance, it is an Indian innovation in a parliamentary procedure. So in existence since 1954, like 0 hour, it is mentioned in the rules of procedure. Not like we've not even mentioned in the rules of procedure. Okay. Motion of thanks. So president addresses parliament in the first session after each general election and the first session of each fiscal year. Motion of thanks must be passed, otherwise it amounts to defeat of the government. That's very, very important. Then privilege, so concerned with the breach of parliamentary privileges by a minister by withholding facts or giving wrong information. Then point of order. So it happens frequently. Raised when proceedings do not follow the normal rules of procedure and extraordinary device. 0 hour, not mentioned in the constitutions or rules of procedure, begins at noon after question hour and Indian innovation in parliamentary procedures. So calling attention, unlike 0 hour, is mentioned in the rules of procedure. 0 hour is not even mentioned in the rules of procedure as well. Special mention, so a matter that cannot be raised under any other rule of business can be raised in a special motion in Rajya Sabha and equivalent to the notice device of Lok Sabha. Now let's see legislative procedure. This is very important for this year examination. Types of bill. Money bill, so only in Lok Sabha, only on president's recommendation, only by a minister. Okay. Financial bill 1, only Lok Sabha, only on president's recommendation, only by a minister. Financial bill 2, okay. So either house, introduction without president's recommendation. It can be introduced either house and without president recommendation. Ordinary bill, so either house by minister or private member, no prior president recommendation is required. Then we have Rajya Sabha's rule. So money bill में तो cannot reject or amend, can only recommend. Must return within 14 days. Lok Sabha may accept or reject the recommendation. In terms of the financial bill 1, can be rejected or amended, but amendment increasing a tax requires president's recommendation. Rajya Sabha has full powers, so can be rejected or amended, but amendment increasing a tax requires president recommendation. समझ गए? Financial bill 2 can be rejected or amended. ये तो है, can be rejected or amended. Presidential assent can give assent or withhold assent, cannot return for reconsideration. या तो you give it या don't give it. You can't return it. In terms of financial bill 1, can give assent, withhold assent or return भी same. ठीक है. Joint sitting, money bill में not applicable. Here applicable, president can summon a joint sitting to resolve deadlock, or it is applicable in bill 2 and ordinary also. Then we have speaker certification. It is required because money bill तो he only will say na. In other types of bill, it is not required. Okay. Then joint sitting of two house and extraordinary machinery to resolve a deadlock between the two house. The president can summon both house to meet in a joint sitting. Who can do? President. ठीक है. फिर applicable to ordinary bills and financial bills only, not to money bills or constitutional amendment bills. ठीक है. Presided over by the Speaker of Lok Sabha, in his absence, the Deputy Speaker of Lok Sabha, in absence, the Deputy Chairman of Rajya Sabha. A bill referred to a joint sitting is passed by simple majority of members present in voting. The provision has been invoked only 3 times so far. Then Supreme Court and High Court लिख लेते हैं. So origin inaugurated on 28 January 1950. Decision of High Court in 1862. ठीक है, जब कलकत्ता, बॉम्बे and मद्रास आया था. And it is single system court adopted from Government of India Act 1935, जो we had read. And one Supreme Court for whole country at present. 25 High Courts, the 7th Amendment Act 1956 authorized Parliament to establish a common High Court for 2 or more states as well. Composition: Chief Justice of India and such other judges as Parliament will prescribe. तो इसमें amendment होते रहते हैं. 34 है, फिर ना composition. Some are talking that 38 भी they are doing. So Supreme Court का जो composition है can be altered by whom? By the Parliament. ठीक है. At present, as of May 2026, the Supreme Court of India has मैक्सिमम सेंसर स्ट्रेंथ ऑफ 34 जजेस। ठीक है, एक चीफ जस्टिस एंड 33 जजेस। और यहाँ पे प्रेसिडेंट में टाइम टू टाइम डीम नेसेसरी appointment judges appointed by the president, chief justice appointed after consultation with such judges of supreme court and high court जिनको हम collegiate system बोलते हैं, as the president deems necessary, other judges appointed after consultation with chief justice obligatory, and such as other judges. Under the third judge's case, consultation with a plurality of judges required. Consultation became concurrence that gave the power to the collegium system. Okay. You have no SP Gupta case, first judges, second judges, third judges case. Now, judges appointed by the president, chief justice appointed after consultation with chief justice of India and the governor of the state. In 2015, the Supreme Court declared the 99 constitutional amendment and the NJAC Act as unconstitutional void. The collegium system was again restored. Okay. Heavy criticism is there of collegium system. Qualification: citizen of India, judge of High Court for 5 years, or advocate of a High Court for 10 years, or distinguished jurist in the present opinion. No minimum age is prescribed. No minimum age is prescribed. Citizen of India, held a judicial office for 10 years, or advocate of a High Court for 10 years. No provision for appointment of distinguished jurist, unlike Supreme Court. Okay. यहाँ distinguished jurist है ना, here nothing like this is mentioned. Oath administered by president, administered by the governor. High Court में holds office until the age of 65 years, holds office until the age of 62 years. Removal so by the president on the recommendation of parliament after resolution passed by special majority grounds, misbehavior or incapacity. A removal must be signed by 100 members of Lok Sabha or 50 members Rajya Sabha. No judges of the Supreme Court has been impeached so far. Same procedure as for Supreme Court judge. The president can also transfer a judge from one high court to another after consulting the CJI. Parliament power: Parliament cannot curtail jurisdiction of the Supreme Court. However, Parliament can extend. Curtail नहीं कर सकता. Here, Parliament can extend the jurisdiction and a power of High Court. Jurisdiction writ तो हमने writ तो we have seen. Now, one thing is called as original jurisdiction. So, exclusive original jurisdiction of Supreme Court is in dispute within central government of India and states, and between two or more states, where a legal right is involved. Excludes pre-constitutional treaties, interstate water disputes, matter referred to the Finance Commission. Okay. Here, original jurisdiction in admiralty and contempt of court matters, election disputes, revenue matters, enforcement of fundamental rights, case transferred from subordinate courts. And advisory under Article 143, President may seek the opinion of the Supreme Court on any question of law or fact of public importance. Court may or may not tender opinion or on pre-constitutional treaty disputes. Court must tender opinion. ठीक है? Pre-constitutional treaty में बुक करना पड़ेगा. Court must tender. Opinion is advisory, not binding on the president. So pre-constitutional treaty, so they can't say no. And opinion is advisory, and president can agree, cannot agree. No advisory jurisdiction for High Court. And then we have UPSC. They're celebrating 100 years, etc. So becomes important. So chairman and members appointed by the president, no qualification prescribed except एक ही है. 50% of the member must have held office for at least 10 years under the government of India or a state government. So ऐसा नहीं है कि only IAS can become. ऐसा नहीं है तो कर देते हैं. That's you will see a lot of non-IAS and people outside bureaucracy becoming the secretary as well. Term is 6 years or until the age of 65 years, whichever is earlier. After 10 year, chairman is not eligible for further employment under government of India or a state. Members are eligible for appointment as a chairman of UPSC or state PSC only, not for any other government employment. Removal by the president for insolvency, paid employment, outside duties, infirmity of mind or body. For misbehavior, Supreme Court advice is binding. Presents an annual performance report to the president, serves as the central recruiting agency. Then comes State Public Service Commission. So chairman and members are appointed by the governor. Term 6 years or until the age of 62 years, whichever is earlier. Removed only by the president. Same grounds as UPSC. After 10 years, not eligible for further employment. So remove होगा president से, appoint होगा governor से. Except as chairman of UPSC or SPSC, serves the same functions as UPSC but for the state. Then election. So it's a multi-member body. Chief election commissioner and 2 election commissioner appointed by the president for 6 years until the age of 65 years, whichever is earlier. Condition of service determined by the president. CESC can be removed only in the same manner as on the same ground as a judge of the Supreme Court. Special majority of parliament. ECs can be removed by the president on the recommendation of the CEC. All three have equal power and receive equal salary equivalent to a Supreme Court judge. Powers, administrative, advisory, and quasi-judicial powers are there. Resolve disputes relating to splits and mergers of recognized political parties. ठीक है, इसकी ना composition में who elects the, the group which elects, तो उसमें composition में ना they keep on altering it. जैसे कन्वेंशन वास की अपोजिशन है, एंड देन वी हैव ना द जज, एंड देन वी हैव द गवर्नमेंट का ना नुमाइंदा, पर्सन हु इज रिप्रेजेंटिंग द गवर्नमेंट. ओके, so this is something now which keeps on changing. So what is the current status? Is there any change? Is there any issue with respect to the council that is recommending to the president? What is the current status? Pause karo and just type it. Okay. Then comes Finance Commission, which is Article 280, obviously constitutional body. Chairman having experience in public affair. 4 other members. Judge of High Court or one qualified to be. Person with specialized knowledge of finance and accounts of government. Person with wide experience in financial matters and administration. Person with special knowledge of economics. Recommendations are only advisory, not binding on the government. A quasi-judicial body described as the balancing wheel of fiscal federalism. Okay, then comes your Comptroller and Auditor General of India, that is CAG. Okay, under Article 148, constitutional body. So it is appointed by the president by warrant under his hand and seal. And term is 6 years or until the age of 65 years, whichever is earlier. Removed by the president on the same ground as Supreme Court judge. No reappointment. No minister represent the CAG in Parliament. Duties are determined by Parliament under the CAG Act 1971, which is written in Article 149. Audits all accounts related to Consolidated Fund of India, Contingency Fund of India, and Public Accounts of India, and corresponding state funds. Submits 3 reports to the President on appropriation account, finance account, and public undertaking. Okay. CAG reports and execution of projects by ministries are discussed by the PAC, that is Public Account Committee. Under Article 279, CAG certifies the net proceeds of any tax. This is finally described as the guardian of the public purse. GST Council 101st Constitutional Amendment Act inserted 279 Clause A. Chaired by the Union Finance Minister, members Union Minister of Revenue or Finance, Minister in charge of Finance or Taxation, weighted voting. Central government has 1/3 voting share. State government collectively has 2/3 voting share. Every decision requires a majority of not less than 3/4 of the weighted votes of member present and voting. Then non-constitutional body में नीति आयोग is an extra constitutional body. ठीक है. Chairperson is Prime Minister. Governing Council headed by Prime Minister comprises Chief Minister of all states and union territories and Lieutenant Governors of union territories without legislature. Vice Chairperson has the rank of Cabinet Minister. 4 full-time members have the rank of Minister of State. 2 part-time members are of academics. Up to 4 union cabinet ministers as ex-officio member. Chief Executive Officer is appointed by the Prime Minister with the rank of Secretary to the government. Fosters cooperative federalism, which is bottom-up approach. Center allocate funds or enforce policy. It doesn't have any such power. Key difference from Planning Commission. ठीक है. Lokpal and Lokayukta Act. Composition and chairman and not more than 8 members, of whom 50% must be judicial members and not less than 50% must be from scheduled caste, scheduled tribes, other backward classes, minorities, and women. Select committee Prime Minister, Speaker of Lok Sabha, Leader of the Opposition. Chief Justice of India and 1 eminent jurist. Salary of the chairperson equivalent to Chief Justice of India, members equivalent to judges of Supreme Court. Jurisdiction, Prime Minister, Ministers, Member of Parliament, and Group A, B, C, D employees. Exceptions, allegation against Prime Minister relating to international relation cannot be dealt with. External and internal security, public order, atomic energy, and space. Complaint against Prime Minister require full bench consideration and 2/3 approval. Lokpal cannot take suo moto action against a public servant. Preliminary inquiry must be completed within 90 days. So this is what you need to know. There are some other bodies which just I want to discuss quickly, which can be also asked. Okay. So this is not the area where I am highlighting, the area where I am trying to stop. Those are more important. One is ED. So ED na Prevention of Money Laundering Act 2002, a criminal law, जहाँ पे ED investigates to trace, attach and confiscate assets derived from proceeds of crime. और FEMA है, ठीक है, वहां भी they investigate. Then there is a Fugitive Economic Offenders Act. Now it is a quasi-judicial, it has quasi-judicial power under Section 50 of the PMLA Act. The ED has the power of a civil court to summon suspects and record statements. The agency can conduct raids and provisionally attach the properties it believes are linked to money laundering. The ED has the authority to arrest individuals as well. Okay. So this is also important because ED is always in news. Okay. Because of various reasons. Now what you have to do is, after watching all the lecture, read the notes, which will be posted in the Karma Yogi IS Telegram channel. I will try to post a practice test as well. CEC वाले का क्या आंसर है? So इसको बोलते हैं सिलेक्शन कमिटी फॉर द अपॉइंटमेंट ऑफ चीफ इलेक्शन कमिश्नर. ठीक है. तो प्राइम मिनिस्टर, लीडर ऑफ अपोजिशन, यूनियन कैबिनेट मिनिस्टर. क्या है? That's the amendment. Okay. This has been criticized. So you have to revise this and it will give you immense confidence. Only one request from my side is to subscribe to YouTube channel, comment if it is helping you or not, like the video, share these videos, and don't forget, once the prelims gets over, don't forget to comment on these videos which helped you immensely and message me. Okay? It gives me immense pride. At the end of the day, what I'm gaining is the satisfaction that I'm helping people to achieve their journey. Take care and best wishes.